Hello again. Assure, insure, and insure. Starting with assure is to make someone sure of something, especially by telling them something positively so they no longer have any doubts. For example, the tour operator assured me that my children would be totally safe on their adventure holiday. Another example, I can assure you that my fellow grand jurors treated me as an equal. They have put systems in place to assure quality output. These are examples of how you can use assure. We are going to now move on to insure. Insure is to make certain. For example, we must ensure that the benefits can be enjoyed by all. The police must ensure that those responsible are charged in court. They do not always check to ensure that the tube originates at the desired location. Again, insure is to make certain. And moving on lastly to insure, it is to protect yourself against risk by paying a company money in return for the company paying you your costs in case of an accident, injury, theft, or damage to your property. For example, under the scheme, the government will insure banks against losing more money from loans and investments. The company was insured against accidents in the workplace. This is how you use insure. Now, assure is to make someone sure of something by telling them something positively so they no longer have doubts. Insure, to make certain. Insure, to protect oneself, person or object against risks. Thank you. Let's start off with freehold and leasehold. These are two kinds of ways of having a possessory interest in property, of possessing property, having the right to use property. I have a house in Canterbury, but I haven't lived there for a long time. Now, I bought that house, I own it outright, it's my house. I own it freehold. But because I don't live there anymore, I've been renting it out to students and they have it leasehold, so as long as they have the lease and they have the property leasehold, they have the right to live there. They don't own it. They can't make any changes and structural changes to the house, certainly not without my permission, but they do have the right to live there. I have a contract with them for this house, sometimes referred to as the lease. This leads us on to the next two terms, void and voidable. So what's the difference between these two terms? Well, let's say I have a contract with you. Let's say that you're renting my house in Canterbury and you breach one of the terms. Now, if one of the contract terms that you breach, if it's a condition, then that can render the contract void. That would mean that, well, a condition is an essential term, it's a material term, it's a very important contract term, and if you breach the condition, then I have the right to decide that I'm going to terminate the contract and sue you for damages. I don't have to do that, but I can if I want to. However, if the term that you breach is a warranty, a non-essential term, it's not a material term. I can still sue you for damages if your breach has cost me money. But I can't void the contract. I can't terminate the contract. So that's the difference between these two terms here. Mistake and fraud in the inducement. We can come back to the example of the house in Canterbury or any type of contract really. Let's say the two contracting parties both have a different understanding so to what's being bought. So you think you are buying a red car from me, I think you are buying a blue car from me. It's an honest mistake that can render the contract void because of a genuine mistake about the nature of the contract. However, if I know that you believe something, some fundamental aspect, some fundamental part of the contract, let's say that you believe you are buying some real diamonds from me, and I know that what I'm selling you are fake diamonds, and I'll lead you to believe that it's a type of fraud, and it's called a fraud in the inducement. I induce you to enter the contract through fraudulent means. I deliberately try to mislead you, and this is the difference between a mistake, which is a genuine mistake between two people over one aspect of the contract, or fraud in the inducement, where one party has deliberately misled another party. Thank you. Now, duress, undue influence, termination and severability, costs and consideration. Two of these are concerning money. One of the pairs is concerning defenses. In American English it is spelled with an S, British English with a C, and two of them concern contract clauses. The first two are types of contract defenses. Defenses to a contract or defenses to contract formation. So what's the difference between duress and undue influence? Duress is when, if at the time of signing a contract or entering into an agreement, I'm under immediate physical threat or danger. Let's say an extreme example. Someone could hold a gun to my head and say, sign this contract. Under that situation, the contract is unenforceable and the defense would be duress. Undue influence would be where a professional abuses their professional relationship with me to persuade me to enter into a contract that otherwise no reasonable person would have entered into. That's undue influence. Termination and severability. Well, these are both two types of contract clauses. A termination clause is the clause in a contract which outlines the circumstances under which the contract will be terminated. Severability is rather different. Severability says that it's the clause which states that if for some reason one of the contract clauses, part of the contract is unenforceable, the rest of the contract still stands. So the rest of the contract will still be valid. Costs and consideration. Well, these are both to do with money. Consideration is what induces one party to enter into a contract, but usually, generally speaking, we are talking about money. And the consideration clause in the contract is the clause in the contract which details payment, the price of the contract. If for some reason this contract then goes to court, if there's a breach of the contract, if it's a subject of litigation, then one side is going to have to pay, and what they have to pay is costs, and costs refer to all legal fees that are incurred during a case. Thank you.